We're here at the Supreme Court Historical Society with Amy Steigerwalt, a professor of political science at Georgia State. She is the author of an article titled Revisiting the Roosevelt Court, the Critical Juncture from Consensus to Dissensus. Her article is the recipient of the 2013 Hughes-Gossett Award, which was named in honor of Elizabeth Hughes-Gossett, the daughter of Chief Justice Hughes and the first president of the Society. Last night at the Supreme Court, she and her two co-authors, Pamela Corley and Artemus were awarded the Hughes-Gossett Award. Congratulations, Professor, and thank you so much for being here with us today.
Thank you for having me. It was a real honor.
So, the Roosevelt Court. Usually historians label courts by the name of the Chief Justice. What was the Roosevelt Court exactly, and who was on it?
The Roosevelt Court lasted from 1937 to 1946 and is marked by the 9 justices that Franklin Delano Roosevelt appointed to the court, including elevating Harlan Stone to be Chief Justice in 1941.
Let's go back to the 19th century when consensus was the institutional norm on the court. Can you talk a little bit about that era?
What we saw during that period was incredibly high levels of unanimity expressed publicly by the court. However, we do know that privately there was more dissensus. So for example, when we study Chief Justice Waite's docket books, we see that there would be dissent on the court during conference, but when the final opinion came out, it was unanimous. And so the process of acquiescence developed.
So there were signs of dissensus prior to the 1937 term.
Yes, though they were more privately explained rather than publicly. So when we look at the private papers, when we see the memos between the justices, we see them disagreeing, but then institutionally deciding to express a single court opinion when the actual final opinion came out. So the rates of dissensus were really quite low, usually under 10%.
Most historians ascribe the breakdown of consensus norms to the management style of Chief Justice Stone. Under Chief Justice Hughes, who ran a very tight ship, the court ran on a tight schedule. But under Stone, who had a more academic style, the justices were allowed to debate more in conference. The conferences went on and on. Can you talk a little bit about Stone and his management style?
Exactly. Stone appeared to really chafe under Chief Justice Hughes' leadership. He was an associate justice under him, and when he was elevated to be Chief Justice, one of the first things that he did was allow conferences to really expand. He would encourage dissension. He would encourage debate. He would very much so encourage the justices to express when they had divisions, to potentially write even separate opinions. And so that really transferred over into his management style as well.
And how did that affect opinion writing?
One of the big things that we saw was really a relaxation of those sort of tight parameters that Chief Justice Hughes had put into place. So for example, it used to be that drafts of opinions needed to be circulated within 24 hours. That was relaxed into multiple days, if not weeks, under Chief Justice Stone. We also saw Stone in a lot of his private papers encouraging his colleagues to write things such as dissents and concurrences, whereas previously there was really pressure not to express these individual versions of dissent or disagreement.
But your article argues that external developments were equally important, especially the 1925 Judges Bill. Can you talk about that and how the court having more control over its docket affected this transformation towards dissensus?
Yes, we think one of the important things is the court doesn't operate in a vacuum. And so externally what was going on is that the court had to decide a lot of cases that were, in their words, when we read the justices' papers, frivolous, deserving of very little time and intellectual energy, yet they had to spend quite a lot of time on them. So they would be cases where the answer was clear and really didn't need to be decided again and again. So what the Judges' Bill did is it allowed the justices to be able to pick their cases, to be able to say, say, no, that case isn't worthy of our time, but this one, where perhaps there is a legal issue that needs to be resolved, that needs to be debated, is worthy of our time.
So were there other external developments that played a factor in this?
We think there were two other major external developments. One was the rise of legal realism in the law schools and in the broader legal community. Legal realism argued that law is not static. It's not black and white. Rather, it is human-made. And there are gray areas. It can reflect the social and political times. It reinforces those norms and also social strata. And so that really played into this development. And tied to that is the second development, which was the appointment of these 9 justices. It was a very short period of time. There was a appointment to the court on average of 1 a year, and it really changed just the entire, not only the composition of the court, but also its vantage point and viewpoints.
So tell me about your statistical research. Is there a particular statistic that stands out for you that really confirms this transformation of the court towards a dissensus-based model?
The one that I found most striking is that the average rate of dissent prior to the Roosevelt court was 10%. During the Roosevelt court, it jumped to 45%, or almost quadrupled.
Did the personalities of individual associate justices play into this?
We really think it did. In particular, the one I like to bring up is Felix Frankfurter. He had previously been a professor at Harvard Law School, and when he came to the court, he wanted that same type of freewheeling academic debates to be expressed. He very much so would encourage his colleagues, even when they disagreed with him, to express their views, to write separate opinions, and to really sort of carry over that debating atmosphere that you saw in the halls of Harvard Law.
So you've talked about dissents, but what about concurrences? Can you address that, the rise of concurring opinions?
Yeah, that's another really interesting side of this, is when we think about debate and discussion on the court, we think about disagreement on the outcome or on the vote, but a concurrence is when the justices agree on the outcome but disagree on the legal reasoning. And that is really a very important form of legal disagreement, even if everybody agrees on the same answer. And so one of the things that was really striking, again, back to the statistics, is that previous to the Roosevelt court, concurrences were incredibly rare. There may be 1 or 2 during a term. They jumped to almost 1 in 5 during the Roosevelt court.
So how did the justices themselves view this new dissensus norm? Were they alarmed by it, or did they enjoy this newfound freedom of expression?
From what we were able to find in the justices' paper, it appears that they really embraced it. They brought with them these academic ideas from the halls of Harvard Law and other law schools, as well as the advent of legal realism, and really like the expression of dissensus. And we saw a lot of encouragement among the justices on that. Now, obviously, they disliked it when their colleagues disagreed with them, but I think in the end, they really sort of embraced this ability to be able to express their disagreements publicly and show the real debates over the law.
Mm-hmm. So did the norm of dissensus continue on in the Warren Court, Burger Court eras?
Most decidedly. We've never seen it return to the levels pre-Roosevelt court. Instead, the high mark of dissensus actually occurred in 1952, where 80% of cases that term were, in fact, dissensual as opposed to consensual, and it really sort of continued on a similar path.
Professor Steigerwalt, I understand that you've expanded on this article into a book with your 2 co-authors, and it's called The Puzzle of Unanimity, published by Stanford University Press. Can you tell me, what is the puzzle of unanimity?
Well, what we were struck by is that in this era of dissensus, we still do see unanimous opinions where every single justice agrees. And what we wanted to do is to try to understand why. We understand where the disagreements come from. We've got justices that have different views over the law. They have different perspectives on what is going on within the law, within the broader social and political culture. Yet the question is, why are they agreeing, now that they're allowed to express this dissensus, what causes them to agree. And so that's what the book focuses on.
Professor Steigerwalt, thank you so much for coming in today for this interview, and congratulations on winning the Hughes-Gossett Prize.
Thank you so much. We really appreciate it.